in August. I'm so glad we have people with us, and it's great to see some of you and hear from you. What we're going to be talking about in this CondoWise learning series, which is our first, is the reopening of indoor amenities and managing risk exposure. At Lee Associates, we are dedicated to learning and education for directors and unit owners in the many years of providing legal services to condominiums across Ontario. We have been working with our colleagues, our clients, our boards of directors, where we also participate individually, and the condo industry over the last few months throughout Ontario to understand where challenges lie in managing this pandemic. We first want to acknowledge the strength of leadership in the condo industry through our property management companies, industry associations, provincial government, condo boards of directors, and many volunteers. You were all there when your communities needed you most, and we appreciate that because Ontario has done very well. Knowledge is definitely power, and with the pandemic evolving on an unknown timeline and society normalizing, we wanted to share our experiences and reflections on how best to manage risk going forward. I will give you the caveat, because I am a lawyer, that this is not legal advice. What we will do is recommend that you speak to your solicitors, whoever your condo solicitors are, to really refine the knowledge that we're going to share with you today, because each condo is unique. So you need to be thoughtful about who lives there, what kind of assets you have, and how you're going to manage the risk. Today, Ashley Winberg, Julia White, and I will be covering Stage 3 reopening considerations for condominiums in the context of the Act. Please keep yourself muted, turn off your video if you can find that button on the bottom, and because this learning series is being recorded. As well, we have a chat function, so if you feel like typing in a question, we'll try and answer as many questions at the end. So I'm going to pass it over to Julia. Julia?
So we're going to start off by just going through an overview of the Stage 3 reopening in Ontario and what that means for condos. So as of today, all public health units in the province are now in Stage 3, except for Windsor-Essex, which is to remain in Stage 2 until the public health indicators show that it's safe for them to move into Stage 3. So in Stage 3, all businesses and public spaces are permitted to open, barring a few restrictions, and provided that they adhere to all public health protocols and respect the gathering and social circle limits. In this regard, Stage 3 permits indoor gatherings of up to 50 people, as well as outdoor gatherings of up to 100 people, which are significant increases in comparison to what was permitted in Stage 2. The social circle limits in Stage 3, however, remain unchanged, as it's advised that social circles be kept to a maximum of 10 people throughout the province, with everyone continuing to maintain a physical distance of at least 2 meters between themselves and anyone else who is not in their social circle. So for condominiums located in portions of the province that are already in Stage 3, you're now permitted to reopen most of your indoor and outdoor amenities, with the exception of the sauna and steam rooms. However, this does not mean that you have to reopen the amenities or that you should open the amenities. There are a number of risks that boards and property managers must consider when determining whether they can safely and effectively reopen these spaces, as well as the numerous obligations to their staff, their guests, visitors, and residents with respect to their health and safety and reducing the risks presented by COVID-19. So next we're going to talk about the condo's obligations that they have under the Act, as well as the Occupiers Liability Act. So condominiums are exposed to the same risks as commercial businesses, and as a result, they must conduct their due diligence prior to reopening their indoor and outdoor amenities. Pursuant to Section 117 of the Condominium Act, condos have an obligation to prevent dangerous conditions and activities from occurring on their common elements. And pursuant to Section 26 of the Act, condos are considered to be the occupiers of their common elements for liability purposes. As well, under the Occupiers Liability Act, condos have an obligation to take reasonable steps to protect persons on their common elements from any foreseeable harm. In this case, because it is reasonably foreseeable, that someone could contract COVID-19 while on the condo's common elements, condos must be diligent and take reasonable steps to prevent against any such foreseeable risk. This could mean that where the risks associated with reopening amenity area, whether it's inside or outside, cannot be adequately managed by a condo corporation, that area should not be opened.
Thanks, Julia. So in terms of managing the assets of a corporation, a board of directors needs to identify legal risks created by COVID-19 in the normal operations of the condo. So while we must normalize, we must not limit our thoughts on what normal really means. In the course of operations, COVID-19 transmission should be assessed for who is likely to be transmitting the virus and how that transmission will occur. For example, who would be exposed? Residents, suppliers of services such as cleaning staff, security, property management, and guests are all categories of concern. But why take on more risk than necessary? Let's not assume all the risk, and let's allocate risk appropriately by breaking it down between, for example, suppliers, the condo, and the residents. All suppliers should have their own protocols for the condominium, and there should be a level of consistency and minimum standard created by those protocols. So what I'm saying is your third-party service providers should already have a protocol, and they should be adapting what the corporation deems appropriate on site. You need to have a level of communication and trust with your service providers that these things are actually being adhered to and they make sense. So in terms of the risk of contracting COVID, let's talk consequences. Death or illness. We all know that. We have lived with that consequence in the numbers that we're seeing. As I mentioned earlier, our numbers are good and they seem to be declining, but you know, we still have to be vigilant. The reason they are where they are is because we have been vigilant. So we have a duty towards people. We are protecting people that are in the condominium environment. The risk of being held liable for contraction does exist. So what do we want our clients to do? We want our clients to take put the best protocols in place and show that they were reasonable in managing transmission. Why? Because our clients feel at the forefront, I think, that making sure they have healthy communities is key. So that's our first intention. The second issue is also dealing with the legal risk associated with being sued. So we need to think ahead. We need to think about the evidence, because just like in your slip and fall cases where you manage protocols, you show what the conditions were like during the time of the snowstorm, the fact that your carpets were cleaned and that snow was removed. This is exactly what we're talking about. So this is normalizing something in the way that we've normalized the risk of slip and fall. We've actually started to think ahead and collect the relevant data. As well, we need to think about the scope of insurance coverage. Is there insurance coverage for a COVID-19 claim? Has insurance coverage been modified because of COVID? It's worth reporting. Is it worth even reporting the claim? Prior to the pandemic, we were experiencing numerous challenges in insurance for condominiums across the country. We had seen dramatic spikes in premiums and deductibles. Accordingly, we want to be sure that we are not jeopardizing at all access to insurance products, and we want to manage that risk intelligently. So again, keeping our numbers of transmission numbers down also has other impacts on the condominium. But before we panic, because I don't want anybody to panic, we don't know the effect of the pandemic on insurance yet, all right? This is going to take us time. However, it's not too early to start managing risk. So that's what we're going to talk a little bit more about. Next slide, please. And we're also going to think about costs. So when we're managing risk exposure, we're going to cover 3 areas: design and implementation of policies, protocols, and rules, the redesign of indoor amenities, and we're going to talk about waivers and acknowledgements, because maybe you've been hearing that floating around as well. And we're going to talk about how we do this in the context of, again, residents, owners, contractors, guests. These are the people that are going to be impacted. Next slide, please. So in terms of policies, protocols, and rules, some of the fundamental policies we should have in place, which I hope you already do, are information management and human rights. Policies, protocols, and rules work to create consistent, transparent, and predictable frameworks for unit owners to exist within, as well as corporations to operate within. As I mentioned before, we're trying to break down risk into baskets. In developing the same, we need to identify the risk we're trying to manage, but also contemplate breaches of these policies, protocols, and rules. What are we going to do, and who is breaking them? We're of the view that we must take a balanced approach to ensure that we are not creating stifling environments. The pandemic itself has been stifling. Not to take on too much risk that we don't really need to take on, and allocate risk to the right party, and around parameters that would be reasonable and practical to enforce. Because here's the thing, we can have as many rules as we want. Do people like rules? Generally, no. So the joy of enforcing them is tedious and hard work for directors. So we want to be reasonable. Policies create an overall statement of intention and form the foundation for protocols and procedures for the condominium. This is where we define relationships as well as allocate risk. Policy statements will often be broad and lack specificity, and that's okay. We want them to have a longer shelf life. They should be used in conjunction with other policies, like I mentioned, human rights and information management. And they should be designed to work with the act, the declaration and bylaws and rules of the specific condo. The line of MTCC 1385 and Skyline cases beautifully curates the architecture of designing excellent rules. The courts there were actually able to see the vision of the drafter and see how those rules became more specific and narrowed in the context of managing short-term rentals. Key policies, information management policies. Managing information for a condominium is more than Section 55 in PPADA. Condos are statutory creatures. They are not natural persons. So we need to give them powers. That's what our bylaws do. With COVID-19, corporations have to collect, disclose, and use information, which is more than what the Act empowers corporations to do in certain contexts. So with COVID-19, until there is a cure or vaccine, limiting the size of a bubble and the social circle will be critical, but also will tracing. So as you open up your gym and you let people use it, and we're going to talk a little bit more on how to do that, it will be important to think about what data you want to be able to use and how you wish to use it if there is an outbreak in your condo, and you can pinpoint it back, for example, to gym use. So that's where we're thinking ahead to. That's the evidence we want to collate. And then we need to think about how we're going to share. Are we going to share that data? Well, in limited ways, and with whom? Are we going to have to talk to municipal health authorities, for example? Protocols are the implementation tools, and that's how we come to bring all these dots together. So some protocols that you need to think about: restrict the number of users permitted at a given time in a common element area, restrict visitor use, reserve the amenity areas in advance, and what's that process? Self-screening, asking users to actually take responsibility themselves for reporting to you on any COVID exposure, sanitizing hands, wearing masks. These are all things that we know actively reduce transmission and are good ideas. Following all directional rules or arrows, and maintaining physical distancing, as Julia had mentioned. Rules also include wearing a mask on the common elements. We're seeing more of those, especially as Toronto has taken that that piece further and mandated the wearing of masks by bylaw in common element areas, indoors, and condos. As well, with rules, I wanted to highlight something else which I think is important: sunset clauses. What does that mean? Sunset clause means that a rule will come to an end without further notice. Is it a good idea? Is it practical? Well, you're balancing interests here. Some people don't want to be under the mask wearing rule forever, and putting in a sunset clause will tell them when it comes to an end. Now, there are creative ways of doing that and drafting it to give you some flex so that you can actually extend it. But the reality is that gives you a window for the board to revisit the appropriateness of the rule given the circumstances around us at that time, because we can't predict if we're going to see a second or third wave. So now we'd like to move on to the next slide, redesign of amenity areas. Ashley, take it away.
All right, thank you for everyone's questions. We'll try to answer them in the chat if we can, but we'll also have a sufficient amount of time at the question and answer period at the end of the presentation. So as Patricia mentioned, it'd be great if we could have a ton of rules, but you need to enforce those rules. And if you have too many rules, it could be difficult to ensure compliance. So another way that a condominium can reduce its risk exposure is by redesigning the indoor amenities to ensure social distancing and promote cleaning and disinfecting and hand sanitizing. So it is advised that at the entrance of any indoor amenity area, that the COVID-19, even actually at the outdoor pool, that the COVID-19 self-screening poster be posted. The majority of the public health units in the province have provided this on their website. I know the City of Toronto has posted one, and it's very easy to read and user-friendly. And then if your condominium is situated in the City of Toronto, at the entrance of each of your indoor common element amenities, including your gym, you also need to post the required mask sign that states that masks must be required as pursuant to the bylaw passed by the city last week. And also, in order to draw any amenity users' attention to the risks associated with using an indoor amenity area and the corporation's exclusion of liability, which I'll be discussing a bit later in the next slide when I discuss waivers, it is advised that a condominium post a clear notice that clearly and succinctly states that the corporation and its agents will not be held liable for any risks or exposure, contraction, illness, injury, what have you, related to a user's use of the amenity or them entering the amenity area, and that the risks associated with using that amenity area clearly be stated in that notice. For instance, if a condominium opens up its exercise room, but it's not having professional cleaning staff clean it after each individual use, it is advised that this be clearly specified so that the users are well aware that it is not being cleaned and disinfected after each individual use, which the majority of the larger commercial gyms are doing. Ideally, for areas like the party room, the media room, the boardroom, and the library, if you have one, if you have two entrances, two doors permitting entry, it'd be great if you could designate one as the entrance and one as the exit, because this will ensure that there's a one-way flow of traffic and that people aren't crossing paths when they enter and exit. It's also advised that condominiums implement a way to restrict entry into certain amenity areas, such as the gym, party room, the media room, the boardroom. This can be done by simply locking the door. However, you're going to have either cleaning staff, the superintendent, security, perhaps your on-site admin or property manager provide entry. If someone has reserved the space, for instance, the gym, or they wish to use it. I'm sure majority of the condominiums in attendance at this webinar right now have already done so, but it's important that you install automatic hand sanitizers at the entrance of every indoor amenity, as well as within the amenity area itself. This is particularly important in exercise rooms. There should be a sufficient amount of hand sanitizers distributed throughout the exercise room to ensure that anyone in the exercise room at the same period of time doesn't have to cross paths and that they can maintain social distancing. The same thing goes for disinfecting wipes, again, particularly in an exercise room. When it comes to disinfecting wipes in an exercise room, it would be advisable that each larger piece of equipment, like each cardio machine, the cable area, the free weight area, that there be individual disinfecting wipes dispensers at each of those locations so that people don't have to cross paths, as well as a garbage with near each disinfecting wipe that can be opened by one's foot, so that people don't have to pass each other while working out in the gym. Also, as I'm sure many of you have already done, in your amenity areas, in order to ensure that or promote social distancing, it's advised that you rearrange the furniture and equipment, which may mean that some equipment or furniture might be put into storage for the time being. And it's also advised that with very visible tape, just like they have at Loblaws and Shoppers, that condominiums place traffic arrows to indicate the flow of traffic, as well as separation markers. And the separation markers are particularly important if you're anticipating that people will be lining up to enter the indoor amenity area or the outdoor amenity area. With regards to an exercise room, because people breathe harder when they are working out, which causes them to expel more respiratory droplets, and because generally exercise rooms and condos are pretty small with consistent air recirculation, this tends to create the perfect environment for the transmission of COVID-19. So in addition to implementing reasonable rules with respect to use of the exercise room, condominiums could also install plexiglass to divide individual pieces of larger equipment. And also, if a condominium has the financial resources to do so, potentially create individual workout stations so that have their own equipment, so that there will be so that users will be able to maintain social distancing because they won't have to be going back and forth. And when it comes to libraries, I recently drafted a couple of library protocols for clients, and in researching what the local public health units recommend, it's advised that for any books that people touch but they don't end up borrowing, or any books that people return, that a condominium place, a return box outside of the exit door, what have you, and that those books be quarantined for 72 hours once they're placed in there, and then only reshelved after that 72-hour period. And that 72-hour period is based upon the protocols that the Toronto Public Libraries have implemented for their library books. Now, with regards to waivers, first off, a waiver is essentially a legal document, waivers and acknowledgements. It's a legal document where somebody relinquishes a real or potential legal right or claim, essentially absolving another party of liability. So it is recommended that condominiums have anyone who's using an amenity area execute a waiver and acknowledgement, because under the Occupier's Liability Act, as Julia mentioned, condominiums do have an obligation to exercise reasonable care to protect persons on their common elements from foreseeable harm. However, under the Occupier's Liability Act, occupiers will not be held liable for any risks that are willingly assumed by an individual. And under the Occupier's Liability Act, an occupier can also restrict, modify, or exclude that duty of care. And this would be done by way of a waiver and acknowledgement. So it is advised that condominiums have anyone who wishes to use an amenity area execute a waiver and acknowledgement, and that this be done in advance of them actually entering that area, particularly ideally when they make the reservation. And it's a good idea that they be given a sufficient amount of time to review the waiver and understand its terms, as I'll discuss shortly. So what the waiver and acknowledgement should contain, it should follow the basic structure of enforceable waivers in Canada, which your corporation solicitor would be able to prepare for you. These sort of COVID-19 waivers and acknowledgements, their enforceability has not yet been tested by the courts in Canada. However, it's presumed that as long as they follow the basic principles of enforceable waivers and contain the following items, which I'll discuss, they should be enforceable, provided that they're executed in a certain manner, which I'll discuss shortly. So the waiver and acknowledgement should contain a statement that it should really state that the risks associated with using the amenity area and clearly lay that out, and that should be brought to the user's attention. The user should acknowledge that they're well aware, they are aware of the risks of using the amenity area in light of COVID-19 and any other special circumstances, and that they freely and voluntarily willingly executing the waiver with full knowledge of those risks. There should also be a statement in there that the user is freely and voluntarily willingly assuming the risks associated with using the amenity area in light of COVID-19, and clearly exclude liability for exposure to and or contraction of COVID-19 or any other risks, injury, loss, damage caused by negligence. There should also be a statement in there that the user acknowledges that they've received a copy of the condominiums corporation's COVID-19 protocols, policies, and rules, and that they have read them, they understand them, that they agree to comply with them at all material times. And in very bold writing, the waiver and acknowledgement should also state that the user agrees to give up their legal right to any and all future claims against the corporation and its agents in relation to the potential exposure or contraction of COVID-19, as well as all other risks, loss, claims, potential damages associated with them using or entering a certain facility or a certain indoor amenity area. So what is the legal effect of a waiver? Well, the Superior Court of Justice recently rendered a decision on this very issue. The defendant was Sky Zone, and that's a popular trampoline park. And the Sky Zone was named as the defendant, and the plaintiff was an individual who went to Sky Zone. They signed a waiver before they went on the trampolines, and then they injured themselves on the trampoline, and they sued Sky Zone. And the issue before the court was whether or not the waiver was enforceable, specifically whether or not Sky Zone brought the exclusion of liability clause in that waiver to the user's attention, so that they were aware of what they were signing and were just blindly signing something. So in that particular case, the court held that an executed waiver can preclude a statutory claim under the Occupiers Liability Act, as an occupier will not be held liable for risks that one willingly assumes, and also because occupiers can sort of contract out of the duty of care by way of entering into waivers. So when an occupier does restrict, modify, or exclude their duty under the OLA, Occupiers Liability Act, through a waiver, for example, the occupier is required to take reasonable steps to bring that restriction, modification, or exclusion to the attention of the person who executed or who is going to execute the waiver. So a corporation has to do more than simply hand a resident the waiver. It's advised that you are there when the resident executes the document, or they can, leave and come back, but it's advised that when they are handed the document, the terms in there that exclude the corporation from liability be brought to their attention. That's why whenever you rent a car, for example, you'll often have the person who gives you the rental agreement circle certain terms in your presence and then ask you to initial them because they want to make sure that those exclusions of liability and statements where you're voluntarily assuming certain risks are adequately brought to your attention when you sign the waiver and acknowledgement. But as I mentioned, because it's impossible to predict with exact certainty how a court will interpret and enforce these, COVID-19 waivers and acknowledgements, it is still advised that corporations take as many precautions, reasonable precautions as possible. And again, that would include posting that notice in the applicable amenity area regarding the exclusion of liability and voluntary assumption of risks.
And I think just to add on to that, the case that Ashley was referencing was really a motion for summary judgment that SkyZone had brought to try and say that there was no issue for trial. And in concluding that the motion should not be granted, the judge was in fact kind of saying, well, you know what, I need to look at more evidence. And I think that's the power of evidence here, is how much awareness is brought to the waiver in order for those standards where waivers have been upheld by the courts to be effective. So, I think this is also, again, about process and protocol. Would you not agree, Ashley? Not just about a document.
Yes, there's also a question here from Carla. Should the waiver be signed each time the resident uses the amenity? That's a great question. We've sort of debated this. I think it depends on the type of amenity. If they're not going to be using it on a frequent basis, like almost daily or weekly, I think it should be executed each time. I would also make each waiver specific to each individual.
Well, and I think
area.
the other thing is to add to that. I mean, I think you need to really think about how you're going to get the waiver implemented, and also because there will be repetitive reporting requirements. You see, this is the other piece, is that you can actually integrate this waiver concept into the fact that people are going to have to update their status. Because even if you come back, let's say 2 days from now to actually use the gym, we still want to know what your temperature is. We still want to know that you haven't been exposed. So the question is, in your design, have you said, well, you know what, if things change from this benchmark, your obligation is to update us. If you're going to do that kind of a statement, then I would suggest the waiver could be one that just actually is one time only. And so it's really how it integrates into all the other pieces of what you're planning to do and the nature of the amenity, I think. Because it's important as well to just make sure people are aware of their responsibilities to you. One thing to do with the repetitive waivers is reminding them, right, that we actually took the time repetitively to ask you. So there are pros and cons to both design elements, I think, as well. And so next slide, please.
Yeah.
I think this brings us to practical considerations, because I've noticed that, we've started to look at the questions in the chat box, and I'd like some time for that. And Julia and Ashley and I will be answering those. But, I think there is a desire to open up amenities, but it needs to be balanced, just like we're seeing in the world outside the condos. Municipalities, areas of the province are at different stages, and it's taken people time to make sure that it is safe. And that's the key thing, is ensuring safety. How well can you manage the risk? The risk, of course, is transmission of the virus. So again, it depends on the type of condo, the type of amenities. Some condos don't have any indoor amenities. They just have common outdoor amenities, such as pools. And we know that a lot of pools haven't opened this year. There will be political pressure. So boards need to actually root their decisions in good data. We suggest that, Elite Associates is a law firm, but we're not medical experts. We suggest that you connect with good scientific, reliable data, and that when you're making your policies, protocols, and rules, that you actually reference the board's due diligence in your minutes. We want to make sure as well that directors are not held liable. that they've actually done and met their obligation under Section 37. So with that said, thank you all for these questions, and I think we should, if we could go to the next slide. Julie, do you want to introduce this?
Sorry, everyone.
Julie, I think you're muted.
Oh, sorry about that.
No worries.
So now we're just going to start taking some questions. There's been a lot of questions in the chat function already, so maybe we can just start with those.
Patricia, do you want to maybe answer Lynn's question about if people refuse to wear a mask, can the corporation fine them?
Yeah, you can take that one if you want.
Oh, really? I wanted you to take that one. No, you can't fine people, even if it's in a rule of the corporation. You can't fine people for breaching the rules. Generally, the fine is an enforcement letter, the cost of the enforcement letter from the corporation's solicitor. That's
fines are just generally not permitted in Ontario. When we were working on legislative reform, many of us did try to get that ability. Stratas in BC do have that, but the government said no, because there's the system has to be well balanced so that there is no abuse of that process. But courts have recognized in case law that there is definitely a penalty effect in receiving these compliance letters, and that unit owners who break the rules or the bylaws or the deck or the act should not, the cost of that breach should be borne by the unit owner. That's the key issue, not shouldered by every other member of the community who abided by the rule. So I think that's where we focus on in terms of enforcement.
Pauletta had a question. So is the notice that I discussed about, excluding liability and what the risks are, in addition to the waiver and acknowledgement being signed? Yes, I would recommend you do both.
Yeah, I think the one thing that's important is that there has to be a communication strategy. That's part of the framework here, is letting people know the kind of environment that we're still in and what the corporation's position will be. And then the notices are those elements that we actually prove to third parties, if we need to, that we were actually actively trying to manage this risk. So hand washing signs, mask washing signs, don't touch the elevator buttons, elements even in our newsletters, use your elbows, use a popsicle stick. Those are all pieces of the evidentiary puzzle that we want to see in place for condos, because they're actually practical, they work. Just those constant reminders. But then the waiver is a different area of legal risk management, because you are actively asking somebody for them to acknowledge before they will get consideration to go into a managed amenity area, that they are aware of the risk. And this is the other thing in terms of the types of amenities, is how are you going to allocate the risk back to unit owners? Are you going to say you're using, for example, I think somebody asked about the playground. What do we do there? Use at your own risk, right? Because I personally don't know, as a mother of 4 children, have watching them on jungle gyms, how you manage that risk, of swinging from the monkey bars, jumping down, and then rubbing your eye. Moms have to be there. I think what you need to do is proactively communicate with parents. Say, look, you please make sure your kids have masks in the playground and have hand sanitizer available, and supervise your child, because we are not. And that's a clear allocation back to parents to manage kids. Because, as schools open, this is another real issue, because they're going to create learning bubbles to manage their exposure. But what if there's a breakout in their learning bubble? That child comes home after school, does what every child does, and goes and plays on the playground. You're going to need to think about that piece, right? Because you want to know where they contracted it and then how they spread it. And the fact that children often are asymptomatic. Go ahead.
With regards to Sandra's question about the outdoor playgrounds, I have a 2-year-old. I live in the city of Toronto, and I did take him to a playground this weekend. And the city of Toronto does have signs at parks, maintain physical distance of 6 feet. It clearly advises that the play structure is not sanitized. So I think it would be a good idea to erect signs of that nature as well.
Yeah, I agree.
Tricia, do you want to take Catherine's question?
Where is Catherine's question? Sorry.
If one were to open the
Oh,
amenities
to confirm?
Yes.
Okay, to confirm, if one were to open the amenities without distributing hand sanitizer, placing barriers between equipment, or repositioning them, not having regular security patrols to ensure physical distancing, one would place themselves at serious risk. You know, I like those leading questions, Catherine, because I felt like I was just led down that path. But yes, I think you are taking a risk if you don't operate with these protocols in place. It would be like me saying I can go to the grocery store and not wear a mask and not wear gloves and not use hand sanitizer and expect that I wouldn't be at risk. I think we need to look at the true benchmarks out here, and that's again due diligence by the board, looking at sources, and I would say yes, you are putting yourself at risk. You know, I don't know about everybody having the resources. I think what's very interesting about your comments, though, look at all the resources you're asking a condo to dedicate, and that's where I think the line is how much is the board able to also manage the financial risk associated with extra protocols? Are we going to have security guards patrolling? And, you know, Ashley and I were talking about this yesterday in preparation. How do you know somebody used hand sanitizer? A mask, very clear on security cameras. I can see that you're wearing your mask and wearing it properly or not. But I can't tell if you used hand sanitizer. You know, and that's the challenge. So how much risk do you also want to absorb? Because I think this is also about putting up boundaries and saying, you're using the common element areas at your own risk. We are doing our best to manage the risk, and we expect everybody to participate to protect the community. But you will get people who won't. There are people that don't believe there's a pandemic. So what do you do about that? So, you know, I think it's a great question. I like it. And I think that there's a lot in that.
And just regards to Sandra had a sort of a follow-up question about putting sort of a waiver or notice in a status certificate, and also to send a notice to all owners. Yeah, that's a great idea.
But we don't modify the prescribed form.
No, but it could be added in.
No, I don't think so. I don't think we should put it in the status certificate, to be honest. I think what you should do is in the covering letter to the status certificate, if you want to highlight things to future purchasers, that's the proper place for that. The prescribed form is the prescribed form. We should stick to that content. You know, there may be increased costs in operating that are unpredictable that you should maybe give people heads up on just generally the impact of a pandemic. But if you're going to be specific about outdoor amenities, things that may change as well, right? Because deals close at different times in months or weeks or days. So it would put a lot of pressure, I think, on managers to maybe keep that up. So maybe we could find a balance. Put it with the status certificate, but put it in a separate letter. Keep that status certificate as pure and clean as possible and simple.
Patricia, do you want to answer Melissa's question about masks?
Which one? About?
Do we need to keep track of anyone who resides at the property that cannot wear a mask due to a medical condition? Do they need to register
with management?
That.
You're the human rights expert.
Okay. Well, if you're a condo in the city of Toronto, the bylaw that the city passed was very vague. It just said it doesn't provide any requirements with respect to like any condition where you cannot wear a mask aside from age. I would advise that if your condominium doesn't have one already, implement a human rights policy as Patricia advised, because that will delineate sort of the way in which the corporation can go through the person's request, that they be exempt from the mask requirement, so that they can produce medical documentation that they suffer from X respiratory illness or something that is made worse, and their conditions made worse when they wear a mask. So that's what I would advise. Though, implement a human rights policy, review the person's request, obtain relevant medical documentation, this again would all be strictly confidential, and that if their accommodation request is approved, that be recorded with the corporation. So yes, I guess technically registered with management.
I think it's better in the long run, right? All that information is confidential. It's done according to the policy. It shouldn't be hard to process this in a timely way at the board level, and it keeps the unit owner record really up to date with the right kind of data. You know, I find the City of Toronto's approach a little bit puzzling because it does indicate that you have to wear a mask, and the only exception will be to the Human Rights Code standard, but that you don't have to prove it. So I'm not sure how that actually works other than just good faith. And I think that's what we're assuming. We're assuming that people understand that other aspect is that you're also protecting yourself and others, right? So that mask is there as a barrier. So there needs to be a medical reason or a really good reason for it.
And just with Bill made a comment about, you know, isn't there a generally understood across the board acknowledgement that there's a risk with COVID everywhere? Yes, you're right, Bill, but we just don't know how this is going to play out. I know my husband just, he's in insurance, and he just advised that there's a bunch of lawsuits, particularly in the States. I've been trying to search to find ones in Canada. I haven't yet been able to see if any have been commenced, but there's a bunch of lawsuits coming out of the States with regards to grocery stores and exposing clients and employees to COVID. It's particularly important in terms of any condominium employees as well. That would be covered by WSIB.
So, you know, I think it's important to keep track and keep good records, because the other part of this that we sort of allude to is contact tracing and how far we're going to do this and who our responsibility will be to notify. I think that's also part of the management of the risk of this, is how you're going to manage spread, because you won't have like the educational learning bubble dynamic. You won't have floor by floor isolation of communities. So you're going to have to manage the whole community and figure out where contraction can occur of the virus. You know, I think the other thing is with the medical masks, I think boards should also do their due diligence around this. It's interesting, you know, in terms of talking and looking at research on people with conditions that might inhibit or prevent them from using the mask, there are very few. So you can even narrow down your focus of exposure of discussion to, you know, not identify in advance, but definitely know which are the types of issues that medical doctors will attest to merit no mask.
Julia, did you want to answer, I think it's Lynn's question, whether or not masks need to be worn in the gym?
So in Toronto, the new bylaw that they passed, it says that masks have to be worn on all common elements. So I believe that we were going along with recommending that masks are worn in the gyms. Yeah. But in terms of whether or not they actually have to be worn prescribed by bylaws outside of Toronto, there is an exemption for when you're doing physical activity. However, if you're looking at what the commercial gyms are doing, you're still required to wear your mask when you're entering and exiting, when you're walking around the gym, and when you're on certain pieces of equipment. It's just when you're able to socially distance that you don't have to wear your mask. But again, we would recommend that the masks be worn at all times while in the gym.
If you can, I mean, I think the whole issue is airborne transmission and its increase when you are actually physically exerting yourself, like singing, speaking, working out. Yeah. So I think as well, you need to look at your physical design to figure out what are reasonable solutions. You know, is plexiglass enough, or is social distancing the best solution? It'll reduce the amount of people that can use the space, of course, but it might be the safer option.
Mm-hmm. There's also another question here. Could you please provide a comment on staff using a digital thermometer to record the forehead temperature of each resident going into an amenity area each time. Would this be helpful? I think it would be helpful.
Yeah.
When you want to ensure that you are taking adequate precautions to protect that staff member, though, so that they are wearing appropriate personal protective equipment and that there is a sufficient distance between them and the individual who wants to enter the amenity area. And that everything be logged and recorded. This also sort of goes to a question that was submitted by Kim in advance of this webinar. You know, if we post the terms of the waiver on the door with a notice that each time they enter, they have to acknowledge and I guess sign in. Yes, it's very important that you have a log of who's entering and at what times and on what dates. That's very similar to what all the restaurants are doing as well, to ensure that if you are notified that someone has potentially been exposed or contracted COVID, that you are then able to notify those other individuals who may have been in close or within 6 feet of them, or use the facility on the same day, for instance. Let's see, I'm just looking through
so I think we also had a question for townhouses.
Yes.
You know, townhouses are different, and I think we need to recognize we have different shapes and forms and sizes of condos, and you have to look at it on an individual basis. Where there are, you know, townhouses, if they're, you know, there are fewer indoor spaces, you know, you can manage it a little bit more practically, I think, just because you don't have that level of interaction.
There's another. Sorry, we're trying to keep up with the questions while staying within the time frame here. I think I saw a question here. If somebody has a medical condition for which they legitimately are unable to wear a mask, can we essentially, oh no, so I guess if someone refuses to wear a mask without a medical reason, can they be told that they are not permitted to access an amenity area? Yes. So I would say if they have not submitted a request for accommodation, stating that on the basis of a disability or so on and so forth under the Human Rights Code, they are unable to wear a mask because it makes a medical condition that they suffer from worse. If someone just refuses to wear a mask without that sort of reason, yes, I would believe you would be permitted to deny them access, if that's a rule that the corporation has.
Yeah, and I think, you know, you can add complications to that where people say that, you know, I need to use the pool as part of my accommodation fee. So, you know, I do think you need to then rethink your solutions maybe, and maybe add a customized solution, which is if somebody needs the pool, they can't wear a mask, that there's a way of them assuming some risk, but also isolating the use for their benefit, and then maybe taking some extra precautions. Because the standard is undue hardship, right? So we've got to find this balance as well, and we don't even know what that means because there have been no HRTO decisions on what undue hardship means during the pandemic. You know, I think the other, I saw another question here about opening up guest suites.
Mm-hmm.
So you're not opening guest suites yet, as we don't want to encourage out-of-town guests from areas where COVID-19 is rampant or risk bringing it to the building needlessly. But we'd like some idea of how other condos might be handling this issue. Ashley, do you want to take that?
Yeah, I recently drafted a set of rules for a condo that wanted to open up their guest suites. I was a bit concerned about them doing so, as you mentioned, because you're having guests come in. However, I did some research, and so based upon the guest suites, from what the World Health Organization has said, they said that, you know, there should be a quarantine period of 72 hours. So in the rules that I prepared, it stated that, you know, the guest suite can only has to basically be quarantined for 72 hours in between each reservation.
And And you should have a heightened cleaning protocol too, I would think. And if it's a third-party service provider, you know, I know at CCI Huronia, we had cleaning experts on as part of the panel. And in one of the first seminars we did, we talked about how areas need to be disinfected. So that's also something that, it's also what kind of investment you want to put into the cleaning of the suite and who pays for that cost, right? Because it could be a higher level of cleaning if you can't always do the 70. Well, and it might be in conjunction with 72 hours. I don't know.
And sort of to that point, and I guess general theme, if your corporation does not feel comfortable with opening a particular amenity, or you don't think that you have the financial resources to keep up with the cleaning that you believe may be required, or the security that may be required to monitor it, you don't have to open them. This is an unprecedented time, yes. Owners may get upset that their facilities are not open when they're paying common expenses, but it's ultimately up to the board to act in the best interest of all residents and to protect the property and assets of the corporation.
Excuse
To
me.
make that call.
Yes.
Can I ask a quick question? I joined in late, and
Sure.
I also have to leave, unfortunately.
Yes, we're
did,
1 minute to go.
Okay, very good. Did Mississauga, for condos, did they implement the masks in common areas?
I know York has. I will look into that today, and we'll post an update. We'll do a bulletin on our website on that today, later on this afternoon. We'll let you know.
Thank you.
You're very welcome. I guess last question, just to close up, I think it's going to be more of a cliffhanger. There's a question from Sandra about AGMs. Patricia, do you want to answer that question, or do you want to wait till our next learning session?
Where is the question? What is the question, Ash? Why don't you read it out?
I manage a lot of small condos, and AGMs have been postponed starting in March. Is there a cutoff at which point the board can reasonably consider leaving the AGM to the next fiscal year?
Oh, that's a great question. No, I think we have a duty to get these AGMs done. I think there are ways to manage these, and we're talking more about how to actually do these AGMs virtually, in person, and hybrid models. So, I think this is the thing. What's the purpose of the AGM? Reappoint the auditor, review the financials, get directors elected. These are all operational things. So, I would never endorse making an AGM optional, because I do think it's important for communities to come together. I think the question is, how do we do this efficiently? And, the challenge will be for some, and we have clients that just don't feel comfortable, and the dynamics of the community, the socioeconomics, and even the age groupings just don't make sense, right? The numbers are too big, and the age of the population is older, so the higher risk categories are there in certain circumstances. So, we do this on a piece by piece basis. We look at the circumstances, make sure the data is there to provide that kind of opinion. So I would never give a broad blanket statement on something like that.
But we will be hosting an upcoming CondoWise learning session on this exact topic, which we'll likely be hosting before the end of the month. So stay posted for an invitation to that learning session that will be coming up.
So with that said, thank you so much for all being part of our first CondoWise learning series. We're excited. I want to thank Ashley and Julia for taking the time to put this together, and for all of you for your questions. And we look forward to talking to you again. If anything comes to mind after the session, please email us. Please check out our website. We also have lots of COVID-19 bulletins. We've been active right from the beginning, keeping you posted and giving you ideas. So thanks again. Stay healthy, and be good to everybody around you. Take care.
Thanks, everyone.
Bye, everyone.
Bye.